Welcome to Access Austin. Today I want to cover library accessibility. Library accessibility is becoming on the radar for more colleges and universities because of recent lawsuits, which I'm going to provide an overview on. But let's start first with what library accessibility is. There are lots of books in the library, obviously, and there are also databases that the college or university pays for that the library provides access to. Now, the books need to be made accessible for students with a print disability. So that means that if a student with a disability wants to use a book that is, let's say, required for a class or something like that, and they need it in Braille, they need to quickly notify the disability office, and that disability office needs to produce Braille for that student. Now, in addition, you also have these databases that have a lot of different types of information up. So they have, information relating to different journal articles mainly. They might have some video and audio content, which may need to be captioned or provide transcription for students who are hard of hearing or deaf. And the library is not always aware that all those resources need to be accessible. And the third-party databases are not always thinking about accessibility on their websites. So, keeping that in mind, let's start to look at some of the accessibility cases that have recently occurred. In 2013, disability rights advocates sued UC Berkeley because their content on their library databases was not accessible and there was difficulty accessing resources from the library. Now, as part of a settlement, UC Berkeley agreed to a couple things. They agreed that students who have a textbook accommodation through that university would receive their books within 10 days, unless that book is a course reader, in which case it would be 17 days. That means within 10 to 17 days, depending if it's a course reader or not, all their books would be, processed and provided in Braille, large print, text-to-speech, whatever the format, they would meet those timelines. Those timelines that I'm saying may not sound like much to you, but they are very fast. It takes a while to receive books and to remediate the books, so I think those are pretty quick timelines that they're setting for themselves in the settlement. In addition, they pledged that all their online library resources like databases and the books in the library would be made accessible for students, and they set a time frame of roughly 5 days, although there's no exact time. They say a rough estimate of 5 days to provide journal articles and those types of content to students who need them for courses. So this was really a landmark settlement because it was the first one that incorporated library accessibility as part of it and making sure that students could access that content quickly. So now let's fast forward to the University of Montana and Penn State University lawsuits that occurred a couple years later. I'm grouping these two together because they both had a landmark thing occur, and that thing is that they put in their settlements that they would meet WCAG, which is the Web Content Accessibility Guidelines 2.0. And at the time, 2.0 was the most recent standards that they could meet. They now have released, WCAG has 2.1, but they were meeting 2.0, and they were really focused on meeting the AA standards. Now, in WCAG, there's single A, AA, and AAA, AAA being the highest standards for accessibility. They were meeting the AA standards. That's what they were attempting to meet. And what was really interesting about these settlements is that they were specifically mentioning WCAG 2.0 AA in the settlement agreements. And in addition, if you look at the University of Penn State, they were also mentioning trying to create a structure of how to evaluate technology in the future so that accessibility would be one of the characteristics that they look at. And basically, for these two lawsuits for the University of Montana and Penn State University, they really emphasized for the first time library accessibility and accessibility in terms of the website and databases. They're really meeting the standards for the website, and they're also looking at accessible databases in conjunction, is my understanding, because from what I can tell, a lot of the databases that are offered by most colleges and universities are not up to the highest standards of accessibility. In fact, if you were to start to remove databases that are not meeting the highest standard of accessibility, you would be purging a lot of databases from a library, a lot, from your library. So that's kind of why we mainly see just the library website meeting those standards and not all the databases. And you may be wondering, well, why aren't these third-party database companies trying to meet these WCAG 2.0 standards and make their content more accessible? And I think, at least at the time back then, there was really less of an emphasis on accessibility, and that they were more focused on protecting their own content and not so much focused on making sure whatever they were providing was accessible to all students. So now I'm going to go into the most recent lawsuit with Cal State Los Angeles, California State University of Los Angeles, and a student with a disability, a print disability, basically a student who has a visual impairment and uses a screen reader, attempted to access materials through the Cal State LA's library and was unable to complete assignments because those materials were not accessible for a screen reader. The student talked to IT, the student talked to the disability office, and the student was unable to get the materials in a timely manner so that they could complete the course. And the student sued under the ADA, and they reached a settlement with Cal State LA. And as part of that settlement, Cal State LA now needs to make sure that all their databases are accessible. So this case was decided in the student's favor, and Cal State LA lost the case, and the judge ruled that all the library databases for Cal State LA need to be accessible. And in fact, the judge said for any college or university, in their opinion, the database should not be offered if it is not accessible to all students. And that is a real wake-up call to third-party databases, because if their database is not accessible, then it won't be available, and colleges won't be able to use it. This is, again, a ruling in California. Very, it's not a federal law for everywhere, but it does show that the courts are starting to look and say that they want to see all databases be accessible. This could also be a wake-up for learning management systems that colleges and universities use, which I'll cover in a later video. But for right now, what I really want the takeaway to be is that now colleges and universities are thinking more about making sure that their databases are accessible. I want to highlight there are two resources in the description, one from the Big Ten Alliance and one from Suffolk Boston University, which provide resources that screened the accessibility of databases that libraries use when using it with a screen reader, which is the most common area where there's inaccessibility issues. And you can check out their reviews of the different databases in the links below. Please like, comment, and subscribe, and let me know your thoughts, and I'll catch you in the next video. Thank you for watching Access Austin. My name is Austin, and I work full-time as an assistive technology coordinator, and I am dedicating most of my free time to producing content for this YouTube channel. If you are enjoying the videos, please consider becoming a Patreon backer. The link is in the description. If you have any accessibility needs or questions relating to assistive technology, accommodations, or website and PDF accessibility, please contact me at accessauston@gmail.com. Thank you so much for watching, and please like, comment, and subscribe, and tune in to the next video.